Especially today, they ought to be. John King's over there, and joining us on the telephone this morning, ladies and gentlemen, it is our pleasure once again to introduce the guy, if you will, the
guy,
the constitutional fellow for constitutional jurisprudence at the Independence Institute in Denver, former professor at the University of Montana, Rob Nadelson. Rob, good morning, sir.
Good morning. You know, your difficulty with my title is very common. So I just generally, here in Colorado, stand up and say, I'm the Constitution guy for the Independence Institute. I don't even try to say the title.
I should just say he's the man. He's the constitutional man.
The guide abides.
All right. Well, Rob, we're very excited to have you on today because there has been so much controversy in the last several months with Donald Trump and the immigration and whether or not you call them anchor babies or birthright citizenship or whatever you want to call it. The 14th Amendment has been called into question, and it's been vaulted into the spotlight recently. And from my conversations with you, the 14th Amendment is perhaps one of the most difficult amendments in the Constitution to understand. Is that right?
It is difficult. Should we go back to the beginning here?
Yes, absolutely. And
okay.
by the way, I just want to let folks know the lines are not open for your calls this half hour. This is going to be a primer, if you will, for the 14th Amendment.
Well, the 14th Amendment was one of three adopted shortly after the Civil War, the 13th, 14th, and 15th. And the 15th, which had to do with voting rights, was passed in response to imperfections in the 14th. And that should kind of be a tip-off, I think. The 14th Amendment is possibly the most inartfully drafted part of the Constitution. And it has been the subject of great dispute, unending litigation, because its terms are have such unclear or indeterminate meanings.
Now, Rob, can I just jump in for a second? Was that the reason? Was because the 14th Amendment was inserted into the Constitution is kind of a stopgap, or if you will, on a crisis type level? We need to fix this now.
Well, yes and no. I mean, the 14th Amendment. Let's go back a second. In 1866, they passed the 13th Amendment, and that abolished slavery, and there was pretty much a national recognition that had to happen. The 14th Amendment was then proposed by Congress really for two reasons. One was a wholly legitimate reason, is that in some of the former slave states, there were moves to take African Americans back to a point not quite of slavery, but to make them something like peons, tie them to the soil and deny them rights that other Americans had. And so part of what the 14th Amendment was about was preventing that. But there was a more political motive also. The 14th Amendment was adopted in order to perpetuate control by the Republican Party over Congress and over the state legislatures, especially the southern state legislatures. And so you have both a praiseworthy motive and a purely political motive. The amendment was ratified by the state legislatures in kind of a controversial process. And normally when we would go to interpret the 14th Amendment, we would look to the state ratification debates. The problem is that we've never really recovered all the information we need from the state ratification debates. And so when people argue about what the 14th Amendment means, or when they try to investigate what the 14th Amendment means, rather than go to the ratification debates, they go back to Congress, the Congress that actually proposed the amendments. Now, the people who carried that amendment through Congress were not, shall we say, the brightest bulbs in the constitutional array. And they made a number of serious wording mistakes. And a lot of the controversy over birthright citizenship occurs because of one of these wording mistakes. But there have been many of them. They used terms that had no established meaning. They used some terms that did have established meanings in ways differently from the established meanings, and they used other terms that were simply ambiguous. And so the result has been, as I said, endless dispute and litigation for the past 150 years over this amendment.
Now, this, of course, is long past the era of the original founders. Is that kind of a signal as to why the language is a bit obtuse?
Well, it's not only long after the time of the original founders, but there's a serious IQ descent from the original founders.
Okay.
I worked in constitutional law many years, and I continue to be awed by the clarity and the care with which the original Constitution was drafted. Many clauses in the original Constitution that people assume are obscure actually are cleared up once you do some investigation. The 14th Amendment, on the other hand, well, let me just give you one example. One of the guy who was the principal sponsor of the 14th Amendment in the House of Representatives, a man named Jonathan Bingham, congressman from New York, was apparently ignorant of a leading Supreme Court decision that the amendment would impact. So he thought at that time that the Bill of Rights applied to the states, and there was a decision by John Marshall saying it did not. And so he drafted the amendment based on not knowing a key item of constitutional law. That's kind of a serious problem, not to know the underlying law when you're trying to amend it.
Wow. So you had mentioned some inartful phrases that bear weight on this particular debate. What words pop out to you as inartfully drafted here when it comes to the issue of citizenship?
Well, let me just give you one example that doesn't apply to citizenship and one example that does. The phrase that no person shall be deprived of life, liberty, or property without due process of law, it's pretty clear what that meant at the founding and what it means in the Fifth Amendment, but many people argue, and they've got some basis for this, for saying it means something different in the 14th Amendment. And so the Supreme Court has taken advantage of that kind of confusion and basically written it the way it wants to. I mean, that's where the same-sex marriage decision came out of that due process clause. So that's one of the problems with inartful drafting.
Now, does that carry on backwards to the Fifth and to the other places where it's used?
The problems exist throughout the 14th Amendment, frankly, especially the first section.
Okay.
But also the fifth section's got a problem in it. Now, in the area of immigration, what the amendment says is that people born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. So, in order for somebody to be a citizen under this rule, he's got to be born in the United States, but he's also got to be subject to the jurisdiction thereof. The phrase "subject to the jurisdiction thereof" has been a source of constant argument ever since the Supreme Court. Ever since the 14th Amendment was adopted, and the whole issue of birthright citizenship hinges on the actual meaning of subject to the jurisdiction thereof.
Tell you what, Rob, we're up against a break. 721-1290. We're going to continue this. The reason this is so important is because the 14th Amendment has been used, as Rob mentioned just a minute ago, in the same-sex marriage decision, also now with birthright citizenship. And we're trying to kind of dig deep, and that's what Rob is so expert at, going to finding the original meaning, because that's the name of his book. The Constitution and what it originally said and meant. We'll be right back with more and continue with this discussion in just a moment. Well, we're back on Talkback. 721-1290 is one of our favorite days of the month because the first Tuesday of the month means we visit with Rob Natelson from the Independence Institute, right in the middle of learning the background and some of the difficulties with the 14th Amendment of the U.S. Constitution.
And just kind of frame it historically. So it's the Reconstruction era, after the Civil War. We're dealing with the issue of slavery and what to do with the people that are here. They didn't walk over the border. They weren't born here necessarily. Some of them were. And there's a lot of issues that are similar to some of the issues we're dealing with today. So it should be pretty clear what to do with an individual that's born here, not of their will, right?
Well, unfortunately, it's not. Again, the 14th Amendment says that someone is a citizen if he's born or naturalized in the United States and subject to the jurisdiction thereof. But when the drafters of the 14th Amendment inserted that clause subject to the jurisdiction thereof, their meaning was not entirely clear. There was some discussion. For example, they apparently meant to exclude Indians who were members of tribes. Tribal Indians were not given citizenship until years later by a congressional statute. So they didn't want tribal Indians at that point to be considered subject to the jurisdiction thereof. It's also clear that if you have a foreign diplomat in this country, an ambassador from Britain, for example, and he has a kid or his wife has a kid while they're here, that person is not subject to the jurisdiction of the United States and not therefore an American citizen. But it's unclear as to what the status is of, or was unclear as to what the status is of children of aliens who are living here with or without permission. And so because it's so unclear, what you have to look at is a series of Supreme Court decisions that have dealt with this particular section. And so trying to figure out whether the child of an alien who's illegally resident here is a citizen, you really can't rely on the history of the 14th Amendment. You have to look at these particular Supreme Court decisions.
In looking at the article you wrote for the American Thinker magazine, it just amazes me the amount of legal hair splitting that has to be done to try to interpret these Supreme Court decisions. Is there a way you could kind of go through some of these decisions and help us to understand why the court chose the way they did?
Or have they even chosen yet?
Yeah.
Yeah, there are two big ones. There's a 20th century decision, but it's less important. The two big ones both come out of the late 19th century. One is a case called Elk versus Wilkins, and what it held was that tribal Indians were not subject to the jurisdiction of the United States. So somebody born into a tribe was not automatically a citizen under the 14th Amendment. Now, I hasten to add they are citizens today by reason of statute, but not under the 14th Amendment. And what we get out of this case is that what matters is the child's status at the time the child is born. If the child is not born a citizen, then the child is never a citizen unless that child's naturalized. We also get out of that case that interpreting this phrase, subject to the jurisdiction thereof, means that we're going to have to apply a British concept called allegiance in testing whether or not a child is born a citizen. And that means that you have to go back to the founding and ask what the rules of allegiance were. Then the second case is a case called United States versus Wong Kim Ark. Wong Kim Ark was a young man who was born in San Francisco of Chinese parents. They were not citizens, but they were residents of the United States. And the court held, and this is in 1898, the court held that this young man was, in fact, a citizen of the United States, even though he had been born to resident aliens here. Now, that doesn't fully solve our problem because they were living legally in the United States, not illegally. But what's important about the United States versus Wong Kim Ark case is it confirms, and it confirms in spades, that this language from the 14th Amendment, subject to the jurisdiction thereof, is to be applied using traditional British standards of allegiance. And by the way, I cover them briefly in my book on the Constitution. And so what you have to do is you go back to those standards in order to try to work out as best we can the illegal alien issue. There's one other point I want to mention briefly because a lot of people don't know this, and I didn't know it until I started investigating it. At the time the 14th Amendment was drafted, there were, in fact, children of illegal aliens in this country, and it was known by practically everybody. I say that because a lot of people were saying, well, they didn't have an illegal alien issue at that time. In fact, they did, because what had happened is that after the slave trade was banned, but before slavery was banned, there were many importations, illegal importations of Africans. So they were illegally in this country, not their fault, of course. They were forced in by illegal slave traders. And then their kids were born here. And you can ask the question of maybe the drafters of the 14th Amendment should have determined whether their kids were citizens or not, but they never dealt with the issue.
Wow. Now, I wanted to get to the test of allegiance, because that seems like it'd be really hard. We as children in school, well, at least when I was a kid, we pledge allegiance to the flag, right? And, some kid that is born here to parents that are from out of state would probably say that same pledge if he were to go to school, and many of them do. So how?
Yeah, the term allegiance, you can't really compare it to pledging allegiance exactly.
Okay.
Essentially, what the British rules were as follows. Number one, if you were born in a country of a citizen, you're a natural-born citizen. Number two, if you're born outside the country, but your father is a citizen in allegiance, generally you're a citizen too. Great example is John McCain, the 2008 Republican nominee for president. He was actually born in Panama, but his father was an American citizen serving honorably in the armed forces, and so he's a native-born citizen.
I noticed you just say father.
Yes, I did. That's right. It's not mother. It's father. And if you want to, we can explore some of the implications of that for Senator Ted Cruz. Let's go on. If a child is born in this country, generally that child is a citizen, even if his parents are foreigners. The great case, United States versus Wong Kim Ark, the Supreme Court case I mentioned, here's a young man whose parents are living in this country, but they are Chinese. But he is considered a natural-born citizen. It goes further. If a couple is visiting this country, a professor is on a teaching visa here, and let's say she's a woman and she has birth in the United States, that child is also a natural-born citizen under the British rules of allegiance, which the Supreme Court says apply in this country.
Rob, I got to stop you right there because we're way overdue for a break, and I want to make sure we can wrap this up in time to start taking calls in the next hour. We'll be right back. And we're back on Talkback. 721-1290 is our number, and we're going to go right back to the phone to Rob Nadelson because we went a little bit long in that last segment. So let's jump to the area where we can transition into the next hour, Rob.
Okay, so here's the conclusion, and I'm afraid that some people aren't going to like it.
Okay.
We said that the background of the 14th Amendment is unclear. The language in the the meaning of the language pertaining to citizenship is not entirely clear, so we have to look at Supreme Court decisions. The Supreme Court has told us to look to the British rules of allegiance, and the British rules of allegiance have a very strong prejudice in favor of children that are born in a particular country being natural-born citizens, even if they're born of foreign parents. It is possible that the court could decide that if the parents are here illegally, that the child is not a citizen, but I think it more likely that the court will decide that the child is a citizen for this reason. The parent, although here illegally, still has an obligation to obey the rest of the laws of the country, and most illegal aliens, of course, do. And therefore they are in what the British would have called local allegiance to the United States. That's enough to transmit natural-born citizenship to the children. That's not, and let me just hasten to add, that's not the decision I would have thought that was the right one a month ago, but that's the result of my research.
I think one of the natural conclusions that will surprise many people is that the court hasn't decided. It's still kind of an open question after all these years.
There was a decision reached by the court in 1981 in which the court decided that it was unconstitutional to deny the children of illegal aliens a public education. Some of the language in that decision, while it's not binding on the Supreme Court, some of the language in that decision points also rather strongly toward the conclusion I just gave.
All right. Now, one thing I wanted to ask you when we come back is just because the children have birthright citizenship, what does that mean to the parents and the rest of the family? Does that automatically mean that they come right along with it or not. So we'll continue this discussion. This is fascinating, and we'll open up the phones to you with your questions as well in the next hour. Rob Natelson with us until 9 o'clock this morning from the Independence Institute in Denver, Colorado. Our telephone number is 721-1290 or 1-800-568-5309. We'll be right back after the top of the hour break. Okay, we're back. I'm Peter Christian. John King is right over there. Joining us on the phone is Rob Natelson from the Independence Institute.
That's right. And we have opened up all the lines. So if you want to call like Charles has, and we'll get your questions on the air. The number is 721-1290. You can call and ask a constitutional question about anything at this point in the show. Right. And you are speaking with an expert. This is a guy who is constantly referenced at the U.S. Supreme Court level for his work on the Constitution. So revel in it. So here we have a couple questions or comments from our Facebook fans from the previous 30 minutes. So I wanted to get those out here. One about from Katie is about the due process definition. And Rob had said that there was a different kind of wording and meaning in the 14th Amendment version of the due process phrase. And she wants to know, can or will the current different definition override the previous definition in the 5th Amendment?
Well, that's a great question. As a matter of practicality, it has. There actually are three definitions here. The original Fifth Amendment definition of due process is that the government can't make up the rules as it goes along. If it prosecutes you civilly or criminally, it has to follow the established law. Many people argue that the 14th Amendment definition also included a certain protection that people had for natural rights, that government could not pass a law that inhibited those rights. The modern definition that the Supreme Court has applied comes down to not only does the government have to act correctly as a form of procedure, but the government cannot interfere with certain liberties that the court considers important. And as a matter of current jurisprudence, that third definition has eaten up the other two.
All right. Here's another question, this one from Mitchell. He says, so if the kids born to illegals are American, that's fine, but it still doesn't ensure that the parents are. Please send the parents back to the back of the legal immigration system.
Well, who's going to take care of the kids, John?
I didn't say it. Mitchell said it.
So what do you think about that, Rob?
Thanks for calling.
Well, he's correct in that even if the kids are citizens, that doesn't mean the parents are. The parents are still not citizens.
Okay.
But I want to be clear here. I did not say categorically that the kids are citizens. I said it's still a disputed question. It will be litigated. It should be litigated. I did say, however, that the probabilities are, given the current political environment and also given the state of the precedents, the probabilities are that they will be declared citizens. That doesn't mean it's a slam dunk.
Let me, if I could, just break down what I understood from what you said and tell me if I got it right. Basically, aside from the Native American special case, which history is kind of decided on, and the slavery case, which history is also kind of decided on, there are four basic different groups. You've got invaders. Their children would not be citizens. Diplomats from foreign countries, their children would not be citizens.
Correct.
A felonious foreigner, this one is a questionable one, I think. It'd be one the Supreme Court needs to decide. We don't really know, but you would lean towards citizen? I don't know.
Sorry, what do you mean by a felonious foreigner?
Someone that breaks the law to come into the country, I think.
An illegal immigrant.
Would be. You use the word felonious. That's why I'm using it.
Oh, I used the term felonious, I think, in a different context.
Okay.
It deals with the case of someone who was born abroad of a father who is a citizen.
Okay.
But that citizen is engaged in treasonous or felonious activities.
Wow.
We didn't actually cover this in the first half hour. This is also part of the Anglo-American definition of allegiance. Let's say I mentioned John McCain, for example, was born in Panama of an American father. If that father had been engaged in treasonous or felonious activities, then McCain would not be a natural-born citizen. Because, however, the father was certainly honorably engaged, then John McCain is a natural-born citizen.
So, for example, if Taliban John had a child, that child would not be considered an American citizen. Okay. So then finally you have law-abiding foreigners. For example, those over here going to school, those over here working for Microsoft or for the talk show because we can't do a good enough job, whatever. Those people who have children here, those children would be considered naturalized citizens.
That's right, and that's true even if the person is, for example, on a student visa. You know, the mom and the dad are over here, and she's on a student visa, and she gives birth. That child's a natural-born citizen. If people are vacationing here from France and they have a child, that child is a natural-born citizen. The only ambiguity, again, concerns the specific issue we're talking about, somebody who entered the country illegally. And I said the courts probably will declare their child a natural-born citizen, but the question is still up for grabs.
All right. I think we do owe it to Charles to take his question.
Actually, we're up against a break.
Oh, okay.
So I wanted Charles to give plenty of time to get his point across. Also, we have Alex on the line. So, Charles, hang on. We'll take a quick commercial timeout. We'll be right back. This is just 2 minutes, and Rob Natelson continues. He'll return in just a moment. We're back. On Talkback, 721-1290 is the number. That's John King. I'm Peter Christian. Joining us on the phone is Rob Natelson. And we did promise right away, I'm going to jump right to the phone and say good morning to Charles. First of all, thank you for your patience, sir. You're on with Rob. Go ahead.
Hi there, folks. Hey, Rob, I've been waiting to waylay you for a long time now for this day. Listen, here's the thing. Now, don't get the mistake because I'm bringing up Iran. I'm trying to find a way to complain about the great negotiating skills of our president. But here's the thing that I understand about it. And what's to object about the agreement? Iran gets to eventually have nuclear weapons, probably isn't interrupted in her work too much inconvenience in working on them now, has $150 released to invest in terrorism, keeps her captive Americans, and is given tools to avoid effective inspections. But here's what I'm zeroing in on. I understand that the president is going to get this in this way, that if the Congress wants to stop him, they've got to vote to know that he won't be able to do that, and then he gets to veto that, and they've got to stop him. Really, they've got to have a 2/3 vote. Now, that isn't the end. I've got one question here. Iran may have a road to a nuclear bomb, but isn't Obama being given a road to nuclear bombing of the U.S. Republican constitutional government? Can't he in the future set up a straw man nation, some little nation, do an agreement and get anything passed here?
I guess the fundamental question that you have for Rob is why the 2/3 vote? Is that where you're going with this?
Well, isn't this a real danger to our constitutional government, our effective government? Doesn't it give the president possible dictatorial powers?
You know, the founders recognized that through the treaty power, you could potentially affect the domestic law of a country. And so they put a very important protection in the Constitution, and that protection was the requirement that any treaty requires 2/3 of the Senate to approve. Not 2/3 of the House and Senate to disapprove, 2/3 of the Senate to approve.
There you are.
As far as I can see, this agreement with Iran is a proposed treaty. It should be treated as such, and for the majorities in Congress to accept the view that the president's that the president gets to have his say unless 2/3 object is a surrender of their constitutional powers. I agree completely with you on that.
Thank you.
Thanks for your call, Charles.
Good point, Charles. Thank you. Let's get Alex. We have a line open, by the way. It's 721-1290. Alex, you're on with Rob Natelson. Go ahead. Alex. Alex, are you there? Hang on just a minute. Try this. Alex, good morning. Are you there? Nope, I don't hear Alex.
We may have lost him.
I'll try to pull him.
Yeah, just say. Okay, let's get Roy on the line. Good morning, Roy. You're on Talkback with Rob. Go ahead.
Oh, good morning, Rob. I always look forward to when you're on the air to learn from you and learn more about our Constitution.
Thanks, Roy.
I have on Article 2, Section 3 of our Constitution, it says, in regards to this treaty or agreement with Iran, it says, the President shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur, and he shall. I understand. It seems like the way it's written here that he first has to go to the Senate and get 2/3 and explain what he wants to do, and then get 2/3 of the senators have to agree to this to what he wants to do before he does it. But in this situation, he's done it, and then he goes to the Senate and wants to get their approval. And it seems to me that they changed. Correct me if I'm wrong, but it seems to me that they changed, instead of a 2/3 majority of the senators present, they changed it to something like 1/3. Is that correct?
Yeah, that's exactly what they did. I mean, they took the Constitution and they put it on its head. Now, what the claim is here is, well, this isn't a treaty, it's an executive agreement. But if you look up the definition of treaty at the time of the founding and examine how the founders would have used the word treaty, this certainly qualifies.
Yeah, that seems like it. How can they do that without an amendment to the Constitution?
Well, they'll do it if they get away with it. I mean, the presidents have been pushing the edge of the treaty clause for a long time. They've been making executive agreements, and generally the courts have gone along with them. I mean, people in power will push as far as they can until you stop them.
Allow me to jump in here, Rob. How would an individual or a group go to challenge this between an executive agreement and a treaty and say, let's call a spade, and you have to call it a treaty? Is there any way legally to do that?
Yeah, I think there are two ways. The person has to establish standing, okay?
Right.
First, if the majority of one of the two bodies of Congress believes it's being cut out of the process, then it could potentially bring a lawsuit. Another possibility is if the treaty affects some private citizen in a bad way, takes away some of his money, then that person would have the standing to challenge it. There was an executive agreement. It was called an executive agreement, agreed to with Iran back around 1980, in which it was agreed that debts owed by Iranians to Americans would be wiped out. Well, an American didn't like that because his debt was wiped out, and so he challenged it. He took it to the Supreme Court. The Supreme Court held that this particular agreement was a valid executive agreement, not a treaty, but the Supreme Court was pretty limited. It limited pretty tightly as to what could be an executive agreement. I don't think the court's rule in that case extends as broad as this deal with Iran.
All right. Hey, Roy, thanks for the call.
I have another question, if I could.
Real quick. You have 1 minute.
Okay, yeah. On Article 3, Section 3 of our Constitution, it says, treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. I have a question here. Since Iran has declared themselves an enemy of the United States, would giving them aid and comfort be considered treason?
Good point. Thanks, Roy. So what do you think, Rob?
Certainly if someone is giving them aid and comfort in the midst of a terrorist operation, yes. Someone simply helping out the Iranian government by advice or somebody negotiating a deal with them, unlikely. This wording, by the way, actually dates back, believe it or not, to the 1300s. And it's in there in order to make clear that treason is a pretty limited offense. It's to be limited to cases where you're actually helping out a country that is carrying out a war against the United States. By way of example, I think that when Jane Fonda went to North Vietnam and aided that government in various ways, I believe she was committing treason.
Okay, we're going to take a break. We'll come right back. Alex and Buck are both waiting to visit with you. Lines are full, but you're certainly welcome to make your question or comment on our Facebook page, and we'll pass it along to Rob Nadelson. Talkback continues in a moment. Hey, thanks for joining us on Talkback, first Tuesday of the month, September to Foist, and we are visiting with Rob Nadelson, who's with the Independence Institute, and let's get right back to the phones. Go ahead.
I was going to say Alex was the one that was dropped earlier.
Right.
He called back in.
So we have him up. Alex, good morning.
Good morning. Thank you, Dr. Nadelson. I had a question. I was wondering if you could update us on the status of us having an Article 5 convention to pass things that Congress never will, like a balanced budget amendment or term limits.
Sure. There are several organizations that have campaigns going on for such a convention. You need applications of 34 states. That means that 34 states have to pass resolutions on a particular topic. The advocates for a balanced budget amendment now claim 27. I don't think it's quite that high because I think some of the applications are defective, but they're far and ahead of everybody else. The Convention of States movement, which has a broader application that would permit for a convention to consider anything that would impose term limits or fiscal restraint or reduce the size of the federal government. They've got 4 applications thus far, although they've been passed in a lot of individual houses of state legislatures. There's also a left-wing effort called Wolfpack, which seeks campaign finance reform. They have 4. The most interesting recent development is that the term limits people, U.S. term limits, and they've been around, as you probably know, forever, they've just jumped on the bandwagon and sent out a letter announcing that they're going to be pushing for an Article 5 convention because they think that's the only way to get term limits for members of Congress or for the Supreme Court into the Constitution.
They're right.
Hey, Alex, thanks for the call.
Thanks for the call, Alex.
Pleasure, sir. And we have a line open now, 721-1290. Buck, good morning. You are on with Rob Nadelson. Go ahead.
Good morning, gentlemen.
Hi, Buck.
Hi. You've spent quite a little time on the U.S. v. Wong Kim Ark as it's important. Ann Coulter claims that in 1982, in her book, Adios America, that was sort of amended, and she doesn't name the case, but she says it was put in a footnote by Justice Brennan. Could you maybe explain the power of a footnote to a court case, rather than the overall decision, and that it stated that it just extended it to children of illegal immigrants? Kind of the argument that they couldn't, how do you really distinguish? But the two questions: do you know about that case that she might be referring to, and what a footnote to a Supreme Court case means to us lay people? Thank you.
Yeah. Before I get into that, let me just say that I've got a somewhat fuller explanation on my blog on this subject, which is constitution.i2i.org. That's constitution. The letter I, the number 2, the letter I.org. The case was called Plyler versus Doe, and it dealt with the issue of whether Texas could deny public education to the children of illegal immigrants. It was not a Citizenship Clause case. It didn't involve the particular part of the 14th Amendment we're talking about today, but it did involve the Equal Protection Clause of the 14th Amendment, and the word jurisdiction is used there. Now, in that case, the court on this point actually was unanimous. The court said that the term jurisdiction in the Equal Protection Clause means essentially anybody within the boundaries of the state. In other words, the way it's usually used. Justice Brennan, who wrote the decision and was 5-4 on the result, who wrote the decision, inserts this little footnote in which he says, based upon the Wong Kim Ark case, that's another reason for believing that jurisdiction is simply geographical, and that if you're within the geographic confines, you're born there, that's enough to make you a citizen. That did not overrule or modify Wong Kim Ark. That little footnote is what we call dicta. It was a side comment by a judge who kind of wanted to make a point or maybe lay groundwork. It does have some weight. in your assessment of judicial possibilities, but not much. And that's basically what I say in the blog post. Maybe a little weight, but really not much. Not a footnote on an issue which is not part of the case.
Oh, on the subject of the 14th Amendment and getting what was actually meant out of the words that are there, Elena has sent me a long discussion, basically, on the 14th Amendment and her interpretation of it. And I wanted to read a section of it because it's apparently a quote from Senator Jacob Howard, co-author of the 14th Amendment with Senator Lyman Trumball, explaining the modifying clause, quote, subject to the jurisdiction of the United States, what is it supposed to mean, in a statement published for posterity in the Congressional Record for May 30th, 1866, where he is on the record as having said the following. And here's the quote from Mr. Howard, quote, I do not propose to say anything on that subject except that the question of citizenship has been fully discussed in this body as not to need any further elucidation. In my opinion, this amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States. This will not, of course, include persons born in the United States, and she has this in bold letters, who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons are or are not citizens of the United States. This has long been a great desideratum in the jurisprudence and legislation of this country. Oh, there's a new word for me, desideratum. Desideratum, okay. Thanks for the fix.
Tell you what, Rob, if you'll hang on to the explanation on that, because we're up against a break, and I want to give you plenty of time to stretch out and respond to that. We also have Dave and John. Everybody wants to talk to Rob Natelson, and we appreciate Rob being with us. We'll be right back. Hey, thanks for joining us on this Tuesday edition of Talk Back. It's September the 1st, and the first Tuesday of the month, meaning we have Rob Natelson joining us. Now, you wanted to respond to what Elena had shared with us, Rob, so please go ahead.
Yeah, what Elena did is she quoted Senator Jacob Howard, who was a senator from Michigan, and who presented the 14th Amendment in the Senate. Apparently, the person who was supposed to be the sponsor of the 14th Amendment was sick that day, and some people have said that Senator Howard misrepresented the 14th Amendment because he was drafted at the last minute to pitch hit. I don't know how true that is. The quote essentially establishes the position that children of aliens born in this country are not citizens. I mean, that's his argument. That argument is often paired with a similar argument, which runs that something like this: the 14th Amendment was based upon the Civil Rights Act of 1866, and the Civil Rights Act of 1866 also provided that the children of foreigners were not citizens. And I think those are good arguments. The problem is that there's also a lot of argument on the other side. For example, and Howard's comments in some ways illustrate the kind of grandiloquent oratory that you see at the time, in which you have this overgeneralization. He says, this has always been the position within the United States. Well, no, it hadn't always been the position within the United States. And is Senator Howard saying, for example, that the child of a slave brought illegally from Africa was not going to be an American citizen? I doubt it. So you always see that's one of the problems with this debate. You see this kind of imprecise oratory that comes out of Congress at that time. And that, I think, is one of the reasons probably why the U.S. Supreme Court simply hasn't followed Senator Howard's view. There is other evidence suggesting that that the court was right, that allegiance was the standard to be used in the 14th Amendment. So as I said, that's one of the frustrating things I find about this issue, because, and with 14th Amendment matters generally, that the original understanding is usually not clear, and so therefore you have to go to the court decisions, and the more unclear it is, the more latitude the courts have.
It is a great desideratum of mine that it was clear, but it doesn't seem to be. Did
I
use it right?
There's another memorable moment in the congressional debates where one of these windbags is introducing the Equal Protection Clause about it's going to ensure that all citizens are treated the same and so forth. So one of the opponents, just as a bit of mischief, raises and says, "What about women?" And the spokesman is, because of course at that time women were subject to all kinds of disabilities, and so the spokesman, he's obviously caught flat-footed. So he comes back and says, "Well, I think it would be recognized that the great position of women is that of wife and mother, and they should not participate in the public sphere, etc." On and on, never really explaining why the Equal Protection Clause didn't cover women. That's the problem with the 14th Amendment debate, and it distinguishes it sharply with a far higher quality of the debates over the Constitution in 1787 through 1790.
Okay, we're going to continue. Let's jump right back to the phone. Dave, you're on with Rob Natelson. Go ahead.
Yeah, good morning. I was wondering if you thought whether Ronald Reagan broke the law in an Iran-Contra event. If you remember back, that was when Ronald Reagan exchanged weapons to Iran, so Iran could send weapons to rebels in South America. And do you think if that was a violation of the law?
I can't give you a definitive opinion on that because I haven't studied all the aspects of that. My gut reaction would be to say no, and this is why. There's clearly a room in the Constitution for executive agreements with foreign powers pursuant to the commander-in-chief power. A great example would be an agreement for the exchange of prisoners. I mean, you don't need a treaty to exchange prisoners with a foreign power. And I think probably the same is true with respect to the shipping of weapons back and forth. But again, that's a gut reaction. It's not a definitive opinion.
Okay, well, thank you.
Thanks, Dave.
Yeah.
Appreciate the call.
Now, that was a hostage trade, wasn't it? I mean, that was part of it.
Well, yeah, and if there's a hostage, a hostage trade, I think would clearly be within the president's powers. The big difference here, a treaty. Okay, let me back up. Any agreement or contract between governments is called a compact. And there's a subset of compact called a treaty. And what distinguishes a treaty is, number one, and I'm using the founding era definitions here. Number one, a treaty is between sovereign powers. So if a state makes a compact, a sister city compact, that's probably not a treaty. So generally, it's a treaty. A treaty is an agreement between sovereign powers. And secondly, it's one that's designed to last a long time. So, a weapons trade, a hostage trade, a prisoner trade, those sort of one-off type things are compacts, but they're probably not treaties. But when you've got something like the Iran deal, where, they're looking 15 years down the line, that's probably a treaty.
Okay, let's get back to the phone and say good morning to John. John, we got a minute before a break. What's on your mind?
Morning, Rob. This is John.
Hi.
I don't know if this has been discussed, I just tuned in, but I have a question as far as precedence goes. And shortly after being elected president in 1952, Dwight David Eisenhower found out that there was 1 million illegal aliens in the United States. At that moment, he initiated Operation Wetback, and he directed all federal law enforcement agencies to round these people up and deport them immediately. And within the coming weeks, they had gathered up 50,000, which were put on planes, buses, trains, ships, any method to get them back to wherever they came from. And so, to me, that would establish precedence in reference to what Mr. Trump is talking about. Now, has that ever been adjudicated? And as far as all these rights go, let's face it, these people are invaders. They are not citizens of our country, and they're not going to be citizens of our country until they do it the right and proper manner. Now, am I correct in that precedence is still outstanding here?
Yeah, tell you what,
okay.
I'm going to ask Rob to hang on to that for just a second because I need to be faithful with my time here. So we'll keep you on here in just a minute, and Rob will answer your question. We'll also get Marilyn on, but this quick time out. We'll be right back. Okay, here we go. 721-1290, 1-800-568-5309. Okay, we just had a question, Rob, about precedence, so if you would mind answering that.
Okay, well, the question had two parts. The first part was, essentially is Dwight David Eisenhower, President Eisenhower's roundup of foreigners illegal in this country. Is that precedent? Well, yes, but you don't need that precedent. I mean, it's the obligation of the president to take care that the laws be faithfully executed. Now, obviously, the president can exercise some discretion in that regard, but he's still got to enforce the law. And I'm not in a position to say to what extent a roundup is or isn't a good idea, but I will say it's certainly constitutional. The only caveat I would have would be that if a person is caught in this big dragnet, he's entitled to some due process. In other words, he's entitled to some kind of hearing to determine whether, in fact, he really is an alien and illegally in this country. It doesn't have to be a jury trial, but some kind of a hearing.
Okay.
The second part of the question is, well, aren't these illegals really in the character of invaders? Because invaders, their children, if you have a foreign invasion, children born of the foreign invaders, they are not in allegiance. They're not subject to the jurisdiction as the 14th Amendment uses the term, and those children are not citizens. And that is, of course, one of the arguments in favor of the Supreme Court adopting an exception to the usual rule that if you're born in this country, you're a native-born citizen. That it's one of the possible analogies that I discuss in my blog post at constitution.i2i.org. The weakness of the analogy, it has its strengths, but the weakness of it is an invader is subject to no laws, is no obligation to honor any laws of the country being invaded. On the other hand, illegal immigrants are under the obligation to honor the other laws as well, and most of them do. And so the argument could be that unlike these invaders, these people have what's called local allegiance to the United States. They don't have natural allegiance. Their natural allegiance is to the country of which they're citizens, but they have local allegiance, and that under the traditional law of allegiance has been enough to create natural-born citizenship for kids. So again, I would refer people to that particular blog post for a more complete treatment.
A question from Dick on Facebook. He says, if United States Code 1401A, which lists exceptions to citizenship for people born in the U.S., and Congress can make those exceptions, why can't Congress add an exception for children born to illegal aliens?
Congress cannot amend the 14th Amendment by itself. The 14th Amendment allows Congress to add to citizens, but the 14th Amendment does not allow Congress to take away citizenship from anyone protected by the 14th Amendment. So if the 14th Amendment protects the children of people illegally in this country, then Congress can't do anything about that other than to propose an amendment to the amendment. What Congress could do, however, is it could pass a law interpreting the 14th Amendment. Remember, this interpretation is still up for grabs. Congress could pass a law interpreting the 14th Amendment to exclude the children of illegal aliens, and that would not be binding upon the courts, but it would be persuasive with the courts, because the courts generally don't like to fly in the face of congressional interpretations. There's a certain amount of deference there. So that's one of the things that Congress can do, is to pass a law interpreting that provision of the 14th Amendment in order to sort of try to add some weight to the scale when the case does go before the Supreme Court.
Okay, let's get Marilyn on the line. Marilyn, you're on with Rob. Go ahead.
Good morning. Could you discuss the Ted Cruz situation? He is my guy, and there's some question, and not in my mind. I've been told that he does qualify as a citizen, but could you give me your opinion?
I have very great admiration for Ted Cruz.
Thanks,
and so what I'm going to tell you is not something I would particularly like to publicize it, but I've made a kind of a pact with myself to call it as I see it in constitutional matters. Ted Cruz was born of an American mother in Canada, of a Cuban father. So he was not born in this country. The traditional rule of allegiance with respect to natural-born citizens has been that if a person is born outside the country, then his citizenship follows the citizenship of the father. And so he would not be recognized for constitutional purposes as a natural-born citizen. Now, he comes back and he says, well, I am a citizen because I was a citizen at birth. And that's true. He was a citizen at birth, but he was a citizen at birth by reason of congressional statute, not by reason of the constitutional definition of natural-born citizen. My guess is that as he proceeds along, if he becomes a real prospect for the nomination, that you're going to see litigation over this subject. And if you were to follow the original understanding of the Constitution, in my view, that's litigation that he would lose.
Wow. All right, we're going to come right back. Craig and Larry will get you guys on. We have more Facebook comments. Rob Nadelson joining us. Only have about 8 minutes left in the program, so savor this. And, of course, we'll have to wait till next month to do it again, so stay with us. Been a great morning so far. We've learned a lot and a lot of information. You have to have a chance to process. Rob Nadelson joining us this morning, and let's get right back to the phones. A lot of folks want to visit with you. Craig, you're on with Rob Nadelson. Go ahead.
Hi, Craig.
Yes. Oh, Dr. Nadelson, hello. So,
Craig, Dr. Nadelson's my brother.
and your father, too, right?
He's a real doctor.
Because of the degree, we couldn't get him on the show. We're not important enough for Dr.
I lied today.
You can call me Rob.
Guys, doctor. She says because you have a doctorate degree. But nonetheless, President Obama, it's been said time and time again, he has violated the Constitution doing this, doing that. And you had another caller call in and said something about Eisenhower and making precedents. So, my comment is everybody whining about what Obama has and has not done. He has just smoked everybody and has them all cowering. So, okay, ta-ta, and thank you very much.
Okay, so
I don't understand the question.
Do you agree that the president has cowed his opponents?
I think that it's not so much the president. I think there's several things going on here. I think, in particular, what the caller may refer to is the inability of Congress,
right,
under strong Republican majorities, to effectively confront the president. And I think there are two things going on here. Number one, despite the decline of the traditional news media, they still have a lot of clout, and Democrats can get away with a heck of a lot that Republicans can't get away with. If you doubt that, think of what the fate of any Republican presidential candidate would be who had 1/10 of Hillary Clinton's baggage.
Yeah.
I mean, utterly unviable.
Yeah.
But the other thing is that, and I've said this on this program before, that while I think that Mitch McConnell and John Boehner are honorable men who are doing what they think is the right thing, I don't think they've been effective leaders of the Republican congressional majority, and I think there ought to be a change. There ought to be changes in that respect. They need a dynamic, excellent communicator as for their leader, and traditionally, those kinds of people only rarely come up through parliamentary systems or congressional.
I was going to say our system basically, if you get to the Senate, it's because you didn't talk much.
Yeah, right. And if if you're from a safe district and you don't really have any serious opposition year after year after year, then you move into leadership, and that's not real great training for a leader. Now, once in a while, the system does produce a great leader. I mean, on the American side, an example would be Newt Gingrich. On the British side, an example would be Margaret Thatcher. But generally speaking, these kinds of parliamentary systems don't produce the great spokesman. And frankly, you need somebody like that because the Obama administration is very politically adept and quite ruthless in pursuing their agenda. And frankly, I don't think they care a hill of beans about most parts of the Constitution.
What we need is a great orator that votes present to be president.
Say that again?
I said what we need is a great orator that votes present to be president.
Votes present, right.
Yeah. Let's get Larry on the line. Larry, we got about 3.5 minutes. What's on your mind?
Okay, I was thinking about this definition of invader, and because these illegals are coming across in over the amount or the number of people that are allowed under our legal immigration system for a country, could they be considered invaders?
Yeah,
And
one of the. I'm sorry. Go ahead. Go ahead.
Yeah, I was just thinking, could a case be made that these are in fact invaders because they're coming across in large numbers?
Well, they're more than invaders now. They're occupiers in many parts of our country.
Yeah.
That came up a few minutes ago, and the answer is yeah. I mean, that's one of the analogies that could be made, and I would refer to people at my essay at constitution.i2i.org. I mean, you could make that analogy. On the other side, though, as I mentioned, is the following difference. Invaders, like foreign diplomats, they're not under any obligation really to honor any of the local laws. On the other hand, the people who come across the border illegally do have legal obligations to obey American laws, and most of them do in most respects. And so the argument could be made that they are in what the lawyers call local allegiance, and therefore their children become natural-born citizens. But just to clarify, I'm not talking here or suggesting that the people who come across the border themselves ever become citizens. We're not talking about that. We're talking about whether their children are natural-born citizens. This is going to have to be battled out in the courts, and I don't think it's absolutely determined who's going to win. I do think, and as I said, I didn't believe this a month ago, but I do think after investigation that the people who argue for birthright citizen are more likely to win than the other side, but one never knows.
I think it's also
Thanks, Larry.
important to, when you say they, that this is a broad stroke characterization. Some people are coming over the border to run a drug smuggling operation to fund a tyrant in another part of the world. And then other people are coming over here to invade the apple harvest in Washington State. And you know, there's a big difference in what that would mean, right?
Yes, and the first example obviously is much better characterized as an invader than the second.
All right, we have exactly a minute and a half left here, Rob. So I
was going to say, I think it's a great opportunity to talk about Rob's book for a little bit.
Let's do that.
The original Constitution, what it actually said and meant, is it third or fourth printing now, Rob?
It's in its third edition. You can get it at Amazon. And what it is an objective look at the meaning of the U.S. Constitution right after adoption of the Bill of Rights. So it doesn't argue the cases one way or another, but basically communicates what that document meant historically. The other source I would suggest people check out is our Constitution Study Center at the Independence Institute, and you can reach that by typing into your computer constitution.i2i.org. That's the word Constitution, a dot, the letter I, the number 2, another letter I.org. Constitution.i2i.org.
Excellent. Rob, it's always a pleasure and a privilege, and we look forward to our next visit.
Thank you.
Thanks,
Good to see you.
All right. Thanks. That's Rob Nadelson from Denver. All right. So, very informative hour and a half. We have like 15 seconds. What's coming up tomorrow?
Walt Carroll will be with us talking about taxes.
Ooh, yeah. All right. So Walt's always another great guest. So for the first couple of days of the month are always awesome, and we appreciate Rob, and we'll look forward to Walt for tomorrow. You guys have a great day. We will see you at 6 a.m. for a Montana Morning.